we'll have to address the elephant in the room, which is the news with Rekieta. You put out a post on Locals. I put out my summary just of the legal situation. It's a very sad situation. And someone said to me, well, you didn't show this much. Well, I didn't reply to it. I have to stop replying to trolls. But they said, you didn't show this much sympathy and empathy when it was Hunter Biden. I was like, if you don't understand the difference between all of this, then I can't explain it by way of a comment in Twitter. But so the bottom line is Nick and his wife and a third person who I don't know who she is, but content-wise, but an internet personality, were arrested on, they got charged with 3 charges. One was felony possession of controlled substance over a certain amount, 25 grams. You'll explain the importance of that. The 2 were gross misdemeanors. One was possession of firearms in the presence of a controlled substance, and the other was child neglect, I believe. From what I understand, and these are public documents, so I don't think I'm saying anything that's not public, apparently there was not a wellness check, I don't know what it is, a mandated monitor who said that they were concerned for the kids being neglected, and then police showed up. This is all in public court documents. They wouldn't open the door. They battered the door down, and they found a bunch of stuff when they came there for that reason from the warrant. Take it from there, because I don't know what more I can add to the situation.
There are substantial constitutional questions about everything connected to the Rekieta case. So there's been a lot of focus in LawTube on the substantive charges and those that want to make sure that Nick's health is in good state, and that's understandable. But I think LawTube should start to focus on the constitutional issues of what's taking place here. You have a high-profile critic of the local court system, of the local prosecutors, of the local police, suddenly being subject to an extraordinary search warrant raid and questionable charges that raise questions under the First Amendment, the Second Amendment, the Fourth Amendment, the Fifth Amendment, and even the Sixth Amendment to the U.S. Constitution. Within 2 days of this case, there are major constitutional questions about the conduct of the government. And that to date has not been talked about at great length. So the First Amendment question is, you look at the underlying facts, and I expected to find something different in the probable cause affidavit supporting detention than what I found. According to the only allegation, there's a lot of false statements being made out there. I love the quartering, but he's been taken in by some of these false statements and false claims. Just go to what is actually alleged in the probable cause. We don't yet have the probable cause for the search warrant. I'm very curious about that. But you go to the probable cause for the detention, initial detention, and it basically says a pastor came and reported concern for the children. That normally leads to a wellness check. That doesn't normally lead to search warrant, knock down your door, arrest everybody inside. So my first is, and only that, there was a week delay. So, I mean, they're seriously concerned for the children, so they do nothing for a week.
Can I stop you there? Actually, my first question when I heard that, because at first I read that it was a pastor who requested a wellness check. I forget what the term is. And my first reaction to that was, isn't that the type of thing that should remain confidential? If indeed, I don't know if Nick is talking to the pastor, isn't that confidential or privileged? And not, there has to be exigent circumstances for a pastor to violate whatever rules of secrecy he's bound by.
I have long opposed mandatory reporting laws, and I understand where they originated. They originated out of concern that child abuse was being unreported by people in a position to know, particularly medical care providers. The problem is it has got to such a length that people cannot seek out counseling. So that I dealt with this with another client where I had to advise them, you can't get counseling. If you go get counseling, then you may disclose something to that counselor that can now be used against you. That shouldn't be the case. We're supposed to have provider petitioner privilege, both in the context of ministers and healthcare officials. And yet these laws are overriding it. And it's always done in the name of, let's protect children. It usually leads to children being in more harm because people in a position to seek assistance don't. So I've not been a fan of mandatory reporting laws. But the second aspect of all this is what that's supposed to lead to is a wellness check. not a search warrant and raid of somebody's home. So that is, I find, and the question is it a coincidence that the judges involved apparently in this effort are judges that Nick has been very publicly critical of and questioning not only their competency but their ethics, that it involves a prosecutor's office that Nick has been publicly critical of, exposing issues of corruption and competence, and a police department he has been publicly critical of, exposing corruption and competence.
And to stop you there for a moment, because I heard the same thing as well, and I had the same queries that you had. Apparently, the judge assigned to Nick's criminal case is the same judge who's involved in his civil case, the defamation case, where he's been a vocal critic of her. And I had the same questions, like, how the hell is a judge doing both criminal and civil? But many people say it's a small town, so maybe they're not that many judges.
Well, that's the issue. You have the biggest high-profile critic in a small county of all these powerful actors. Like, people ask me now and then, why do I live in Las Vegas? It's because I don't practice law in Las Vegas. I don't practice law in the state of Nevada. It provides a degree of protection from if you know anything about Las Vegas police, you would know you'd want to be careful. If you want to practice law in Nevada, don't live in Nevada. I'll put it that. We'll get to that when we get to the Gruden case a little later on. But so I have First Amendment case questions. I mean, were biased, prejudiced, partisan officials part of the entire process? We'll get to this when we can talk about the Trump case, in authorizing and approving this extraordinary search warrant. Then you get to and that could be discriminatory, selective, disparate under the First Amendment, all legitimate issues that also President Trump has raised in all of his cases. Then you get to the Second Amendment issues. I was curious. I was like, okay, why is there a gun charge here? He legally had the right to possess the guns. He's got no criminal history of any category. And I thought, well, there must be something in the probable cause for detention that will say the guns were in the presence of the children or something like that. Nope. It's in his private bedroom, his personal bedroom. In the bathroom of that bedroom is where they found the substances and where they found a gun and some ammunition. It's like, how is that grounds for, under the Second Amendment, to charge anybody with a crime? And then you have the bail provisions that say, because you've now been charged with this crime, you have no Second Amendment rights. You lose your right to possess a gun in Minnesota under their regular routine conditions of bail in Minnesota. That strikes me as violating the Second Amendment. And we've discussed this before. Remember the Oklahoma case, other cases. There is no constitutional history, and that's the standard under Bruin, of criminally punishing someone merely for possession of a gun, merely because they've also been charged with possession of some illegal substance. It's only been illegal use of a gun at the time you possess or are under the influence of illegal substances or under the influence beyond the range of what's legal, such as alcohol, and usually in a public place. And so I think that the criminal charge of the gun charge against Rekieta patently violates his Second Amendment rights. I think the bail condition violates his Second Amendment rights.
Well, the gun charge is a gross misdemeanor, so 364 days maximum sentence. The big one is the possession of a controlled substance. The other thing is
they use it as an enhancement for sentencing purposes on the drug charge. So there's a dual level influence of that particular aspect. And there's no allegation of any illegal use of a gun. No allegation that he used the gun in a public place. No allegation that he used the gun while under the influence.
The report mentioned a spent shell, which was near the Glock, which I don't. It sounds scary. Was he discharging the weapon, the firearm in the house? The bail, Robert. We had the same two questions, I think, as well. And if I made a mistake, I'll correct myself on Twitter. They were saying 50,000. What was it? Unconditional. It was a UR. There was an acronym they used, and it sounded like it was $50,000 bond or all of these conditions. When in reality, what was agreed to was 50,000 and a bunch of conditions. Correct?
No, it's or. So Minnesota's unique. Most states, that's always an and. In Minnesota, I can tell you why they're doing this. They're doing this to evade constitutional challenges. Though they don't evade it in the process. because you can't impose a monetary fine on the assertion of your constitutional rights or remedies. That would be a form of unreasonable bail under the Eighth Amendment, just as it would be an excessive fine if it were a fine as some form of civil or criminal punishment under the Eighth Amendment. What they're doing is they're setting themselves up to make it easy. Say, you didn't have to apply any of these conditions as long as you posted bail. They give the two options. Either you post bail and then you have no conditions on you, none. Or you agree to the conditions and then you're out on your personal recognizance and you don't have to issue. And the theory is that either one will secure your appearance later. How does taking away somebody's Second Amendment rights secure their appearance later?
But then, I mean, why wouldn't the options? I thought they were alternative, and then I thought they were cumulative when they were agreed to. It was 50,000 bond, which he would have only had to post 10% and get the rest by a bonding company, or these conditions. Or these
depends on the jurisdiction. There's some places that are pure cash bail where you have to post the whole amount. I think in Minnesota you can get a bond agency to post.
Okay, so he agreed to the conditions, which include travel restrictions, drug testing. What else?
But also loss of gun rights.
My own question was, independently, what happens if someone's out on bail and then there's a random drug check or alcohol test check
they try to, that raises separate Fourth Amendment issues, always has. Drug testing while on bail, to me, is also unconstitutional. It's arisen in the probation context, even. The Ninth Circuit called it an unconstitutional condition. So in my view, that's, again, and what they're trying to do is use scandalous or sensational facts to slowly strip us of all of our liberties and rights. They're trying to use bail as a control mechanism. And so that's its own independent problem. The same with controlled substances. For those folks out there that might be like, well, I really hate particular substances, don't think person should ever use them. Okay, just remember right now the state of Pennsylvania has already said that having Amos Miller's raw milk in your refrigerator is the exact same as having any illegal drug in your possession. Now imagine if they could you have Amos Miller's raw milk in your fridge as grounds to strip you of all your Second Amendment rights. And then we get to the next charge, the child endangerment charge. I assume there was some connection. There's none. They're simply saying if you possess an illegal substance, we're going to call that endangerment of a child. And it's like, that strikes me as a Fifth Amendment violation, because under the Fifth Amendment to the U.S. Constitution, the most fundamental of all fundamental rights under the Due Process Clause, as the Supreme Court itself has acknowledged many times, is the right of a parent for control, custody, and care of their children, for them to make those decisions. That can only be invaded if you showed harm to the child. There is no allegation at all that he has caused any harm to his children ever.
And now, so let me.
That's according to the government. I'm just going with the government's own probable cause declaration.
Well, no, and that's what I was going to say. Is like there's a lot. Say the quartering, for example, says Nick has been blackout drunk, and then 4 hours later talks about driving his kids around. You're not sober within 4 hours, whatever. A lot of other people have seen what I'll call the public meltdown, which I think is related to alcohol abuse at the very least, and infuse that or combine that. Whereas from the state's perspective, that it's not like they even referenced the streams.
Exactly. If that was the basis, it would have been in that. See, I thought they had some independent basis for this. They had none. All they did is some. And this will get to the Fourth Amendment issue now. I thought there was something more here. Not okay. You found something in a dude's bathroom, and that's it. All of a sudden, you're going to take that as a grounds for a search warrant. You're going to take that as a grounds to take away Second Amendment rights. You're going to take that as grounds to take away care, custody, and control of children. You're going to use that to let child endangerment. When the child, I read the statute requires the child be in the presence. They're interpreting that so broadly that they can basically take away anybody's child if any substance you're using they don't like. And remember, the state of Pennsylvania includes Amos Miller's raw milk in that. That's how nuts some of this is. It violates constitutional rights, and they're using the scandal and sensational facts, and people like the quartering misunderstanding the facts to try to get away with a severe deprivation of constitutional liberty.
Well, no, I think a lot of people are joining what they know personally and what they've witnessed over the last little while with the law. So they're saying, okay, well, I know all this stuff.
That's where they're like, no one has witnessed anything bad, but I assume they had these facts. They don't. Anything negative towards the children at all, other than they thought the house was messy. And I was like, hold on a second. That's not grounds of
Well, no,
or alleged child endangerment. I mean, then I committed every other day if that's the case.
And like that, the document says, dirty dishes and the house is sort of in disarray. I'm like, crap, if someone comes through this at my house and says there's dog poo and streaks of dog, they won't know it's dog blood, but like one of our paralyzed dogs, she sometimes bleeds and drags her feet around. And I mean, that much I'm very skeptical of. I think what a lot of people are doing is merging what they have seen personally and publicly of Nick with these charges.
In the live chat where people are saying, well, I know this in general about people who have problems with alcohol or drugs or gambling or other abuse, addiction related issues causing issues with children. Yeah, but we don't presume things like that. We don't assume that everybody that has an issue that you have to prove it with actual facts. And that's the problem here.
Well,
now we get to the Fourth Amendment problems next.
Oh, before you get to the Fourth Amendment, let me just throw this in because people say, look, a pastor was so concerned. He said a wellness check on the kids, and there has to be a good reason for that. Who the hell knows what information the pastor had? We are living in a world where I'm not trying to be over cynical.
Well, I thought there was more detail. I mean, that's what I thought. Okay, this is a detention warrant. This is saying this is the grounds for all of this. And I thought, okay, there's going to be a lot of details of what the pastor said that really precipitated serious concern, and that it's not there. I mean, I was stunned it wasn't there. I was like, wow. They saw this as an opportunity to go after one of probably their biggest critic, given how small a county they are. Their biggest critic. They're like, this is a chance to shut him up and punish him for yipping about us for years. That's what I see, because that pastor's complaint was more like, hey, I got a basic concern. It was not here, this specific. Nothing like that was there.
And people can say, like, I see some of the chat, like, you're defending them. Even, first of all,
I could care less about those people. So I care about constitutional liberty. I want Nick to do well. I want him to get good counsel, all those things on a personal basis. But we're not the shrink show, nor are we the moral judgment show. We're the law for the people show. And we care about constitutional rights and liberties. And guess what, folks? You dig into a lot of constitutional rights. Miranda wasn't the sweetest human being on the planet. So, I mean, you give people that some of our core constitutional rights when they want to eviscerate our rights, they're not going to go after popular people. They're not going to go after people who have the most perfect life history. For those that don't remember, Rush Limbaugh had his own addiction problems. Half of America will either have a personal close relationship with someone or themselves have an addiction problem at some point in their lifetime. That's so these people that get real judgmental, it's like, hold on a second, this is pretty darn common. Mark Robert does great work in terms of helping people. You can go to America's Untold Stories. He covers that. You can read his book about Rehab Nation. Mm-hmm. That there's good stuff there. But on the law side, they're trying to eviscerate his constitutional rights. And I see all a law tube that the not talking about this. And it's like, to me, once I dug in, I was shocked at what I was seeing.
Well, especially in the context of that umbrella guy's covering it. I mean, he's also concerned for what Nick he considers to be a friend, but like they called CPS on that umbrella guy as well. Anonymous calls. Yes. Who knows what information the pastor is acting on? Well, they've got 5 kids.
That's the Fourth Amendment issue. So I thought, okay, so first of all, and for people out there, when people get swatted, that's usually a Fourth Amendment violation by the government. The government can't rely on anonymous information, third-party information, hearsay information as their sole basis to go and take a ram and bang down your door in your house, right? That's not what is allowed under the Fourth Amendment. You have to have probable cause of a crime, and under internal public policy, it's discouraged. We'll get to this when we talk about Trump and Mar-a-Lago. You got to be discreet when you're executing search warrants, okay? Search warrants should be for exceptional cases. Right? That's drug dealer cases. How many times have you heard of a search warrant being executed on a first-time alleged a drug user? I mean, this is very rare. I'd be curious how often they've done it in that small county. So again, going to the First Amendment issues, but what was their basis for probable cause? So the pastor doesn't have any firsthand information, doesn't report any firsthand information. Okay, so now you've got and he's reporting it from somebody else. So he's like, you got third-hand information. If the information may be privileged in the way in which he got access to it, which raises its own separate set of questions. He apparently had no detail. I mean, of any actual neglect or abuse. He didn't say, okay, that the child is having this problem or this problem. None of that. It's, hey, I think that there may be an issue with substance abuse of the parent. I'm concerned with how that impacts the kids. He's clearly asking for a wellness check. He's not asking to raid the house in front of the kids with a bunch of armed police officers ramming the door down. And so I think there's serious Fourth Amendment issues present here, because I'm very curious how they got to probable cause, because by golly, it ain't in that detention warrant. And then we still have another one, because they're busy violating every constitutional liberty they can figure out there in that small Minnesota county. We have the Sixth Amendment issues. They apparently were on notice at some point early on that he was the counsel for his wife and for the third person that was arrested there. It's one thing is, why are they arresting everybody? It's like they arrested everybody in the house. You mean if they do some sort of raid at some place, a party or possession, you're not supposed to arrest everybody, but they arrest every adult. So the kids get forced out of the house. That raises its own question. Clearly, they didn't have much evidence on the third person, because then they dismissed the charges 2 days later.
So her name is April Imholt. They dismissed her charges?
Mm-hmm. All dismissed, all gone, all finito.
Some people might be hypothesizing that means she's cooperating with the state.
There's always a possibility that that's why they arrested her. But here's the issue. Did they talk to her? If they knew Rekieta was her lawyer, did they talk to her without notice to Rekieta? Because that's what Rekieta reported. He said he had been foreclosed from talking to either his wife, who he was representing, or her, who he was representing.
Now, let me stop you there.
Put him on immediate notice. He says he put them on immediate notice that he was representing them. So that's Sixth Amendment right to counsel issues. There's also Miranda issues, because they'll said they would have Mirandized everybody. But it's like, did they arrest her solely to scare and terrify her into telling whatever story they wanted her to tell outside the presence of counsel? So they didn't have probable cause for the arrest, didn't have probable cause for her detention, and then invaded her Sixth Amendment rights in order to secure whatever favorable testimony they possibly could as payback to Rekieta being a high-profile public critic.
Let me ask you the question before I'm going to read some of these chats, because they have some decent questions in there as well. It's one thing to say I want to represent someone and I'm being denied counsel. Can a co-defendant who's an attorney represent another co-defendant?
Oh, yes, and I'll give you an example, because the government's done this nonsense to me. So one of the games the government likes to play, they did it to Gotti when they finally got him, is that they try to find a way to separate out the client from the lawyer. And now I was very public saying, and if you're in a situation like Nick's, get independent counsel right away. It's the first call you make. You make sure they're all lined up. You make sure the cops all know. You make sure everybody all knows. That's just tactical advice. Putting that aside, that still doesn't change the constitutional analysis. So absolutely, he can represent them, and they can challenge it at a later point about whether there's a conflict, an unwaivable conflict of interest. Okay. But when the government has done this multiple contexts in my cases, they try to always separate out the defendants. Usually the defendants are best served with joint defenses, often joint representation. But because they know that the best way they get people to point fingers at each other, both of them usually go down. That's how that tends to work, particularly in husband and wife situations. But the other aspect is they also, if the lawyer's real effective, they go after the lawyer. So years ago, I had a case in which my client sort of stumbled into a massive Obama scandal. And the scandal was that the Obama administration was using the IRS to enforce Obamacare. And it was the pretext by which the Obama IRS who already had everybody's most private information through the financial records they confess each year on their tax returns, and their other mass gathering of it. Part of why they want the PayPal information and all the rest. It's to put you into the surveillance grid. It's not about making sure they accurately collect tax. But what they did in this context is they were stealing everybody's medical records. They were going around to medical care providers and record keepers especially, and forcing them to turn over all of their medical records. This was information that gave them, I called it J. Edgar Hoover's wet dream of a blackmail file. And they had stolen the medical records of every judge in the state of California. that, and I'm sure they were doing it across the country, of every Major League Baseball player, of every screenwriter, of every movie director, of every movie actor, of every movie producer. They were stealing all of it. And basically they had blackmailing some of the most powerful people in the world, either in terms of social influence or political influence or legal or economic influence. Because, they knew who had been in for sex addiction rehab treatment, for example, right? That kind of thing. And he stumbled into it and started to report it. And the IRS decided to put him under microscopic inquiry for criminal tax cases and tried to lock him up for life. And he hired me, and I was the hit. I exposed what they had done on the medical records, started exposing their other misconduct. The prosecutor involved was very politically connected. He was the guy that was picked by the Obama administration to handle fast and furious charges in another jurisdiction. That's how politically ambitious this guy was. But the IRS got very agitated, and his office got very agitated that I was having a lot of success. And so they decided to manufacture a case where they were going to accuse me and my client of being in a conspiracy to assassinate the prosecutor on one of the most ludicrous, asinine, absurd charges ever. But their whole goal was to separate me from the lawyer. Say, oh, now you can't represent him anymore, Barnes, because now we got an accusation against you two. And if you don't play ball, Barnes, or be nice, maybe, this has a death penalty statute that this carries with it. And my attitude was, F you. That I'm going to protect my client's constitutional rights and my own. And, let's see how this all works out at the end. In the end, by the way, he didn't serve a single day in federal prison, didn't pay a single fine, but he did recognize the need to get out of the United States, and he's not come back since. And this was a guy who was a deep-hearted American when the whole case started. So this is an old game. They did it to Gotti. They got Gotti talking to his lawyer on tape in a way that they could interpret in a certain way that got a judge to say Gotti could no longer use the lawyer who successfully got him acquitted repeatedly. So this is an old scam of the government, and it's never an excuse, and they know that. So that's where I think all the law tubers out there, I understand people's personal concern for Nick. Everybody wants Nick to do well. Nick has been a stand-up guy for a long time. He's helped a lot of people. By everything I've ever seen, he's a stand-up family man. He's a guy that stood up for Kyle Rittenhouse, was his lead advocate in the court of public opinion. And I'm glad he exposed corruption when he saw it in his local jurisdiction. Everybody wants him to do well. But what LawTube should start to focus on, in my view, is what the heck's going on in that county. This looks like serious, significant constitutional violations as punitive retaliation against someone they don't like. And we should all be concerned about that, because that can happen to any of us who call out corruption or fraud in our government.